computer. Good morning, everyone, and welcome to our very first episode of From the Bench. I am your host, Aaron Cartwright, and here is my co-counsel, Laurel Curtis. Today, we have, on our very first episode ever, so don't judge us too harshly, we have the Honorable Judge Matthew Wright. Judge Matthew Wright is the presiding judge of 2 municipal courts in Texas, as well as the visiting judge in Tarrant County. Now, he's also a professor at Baylor and Texas A&M School of Law, and was one of the people who had, well, I mean, he may decide to call it a pleasure or not, but he was one of the people who taught me. So we'll see how that works out. Judge Wright, thank you for being here today.
I'm not for sure I want people to know that, Aaron, but
I mean, that's your thing. I hope to, make at least 1 or 2 institutions proud.
Yeah, that's right. That's right.
But we greatly appreciate you being here today. Thank you for taking the time out of your schedule. I know that you were trial prepping yesterday.
Yeah, we did have, we were getting ready for, we've been trial prepping for about a month now. We had a felony jury trial getting ready to go on Monday, and the state dismissed it at the last minute. So needless to say, I had some new free time. And so I figured, why not spend it with Aaron?
Oh, I forgot to mention, he's also a practicing attorney. So he wears like 6 or 7 hats at this point in time in life.
Well, and I think in one of your prep questions, Aaron, you said, what's your background as a judge and stuff. And, and I'm glad to be your first, because I think I can be the tech guinea pig with you too. And I always appreciate people that are pushing the tech. I've got 2 courts of record. I've got 3 municipal courts. I'm a visiting judge in Tarrant County. But because of how they work that type of system within the state judiciary, I still have to make money somewhere. And so I do wheel work at the federal level in Waco, and I do wheel work outside my counties that I actually am a judge in. And so you get to have an interesting perspective. You get someone who's on the bench a couple times a week, but then is also in the courtroom as a practicing attorney. So you should get some interesting answers today, that's for sure.
And you said the key words, from the bench.
Right. You told me to do that. So.
Oh, man. Okay. So, Judge, let's get started. You talked a little bit about your background a second ago, but Can you expand a little bit more into your background?
Well, first of all, I wasn't an attorney when I started working in my professional adult life. I actually went and worked in healthcare and in nonprofits for over a decade prior to becoming an attorney. So, I always tell people that my perspective is a little different than someone that goes from grade school to high school to college, college to law school to the point that they know everything and now are a practicing attorney. I've had a varied career. I've worked as a janitor at a healthcare system, and then my last job in healthcare was interim CEO. So my perspective is a little different. I don't see things as black and white as a lot of attorneys do, because I lived in the real world for 10 years before getting into the world of absolutes. So that's a little bit of a different background that I think that I have. I was trained in Middle Eastern affairs and politics and negotiations, and I did do some of my legal studies in Israel. And I do have some international experience. So those are just some things that kind of contribute to it. So
how on earth do you manage it all?
You get up at 5:30 every morning. That's what you do, is you get up, grind.
That makes sense. So having the life experience that you had before coming to the bench, what really inspired you to become a judge?
Well, what inspired me to become a lawyer first was how horrible the attorneys did in the jury trial, because I was a jury foreperson, and I was working at the time, and I had a week off, and I got put onto a jury. I was a jury foreperson on a felony, and the lawyers were horrible. They were unbelievably horrible. In fact, the not guilty verdict, if all of us jurors were talking, we made the decision to go not guilty, not because of anything the state or the defense attorneys did. It was because of one statement a witness made. And the crazy part was, it wasn't even a statement that the attorneys asked for. The witness, that it was a police officer, the police officer self-disclosed this piece of evidence on the stand. Neither the defense nor the state had asked him a question, but all of it, and no one objected to it. And that's to give you an idea of how horrible it was. So I literally walked from the jury box to the and registered for LSAT. So the time from the jury box to the LSAT was approximately 30 minutes. And then after that, when I got into law school, I had a couple professors that just said, "You have the right temperament for what we need in the judiciary. Why don't you become a judge?" And I was like, well, there's a few stumbling blocks to get into that. But that's kind of what happened.
Wow. Wow. That is definitely different. I mean, you're the first one on From the Bench, but I don't think I've ever actually heard that story before. And I've known you for years now.
Yeah, that's how it all happened.
That's impressive. How does your background play into your thought process while you're on the bench?
Well, I think probably I try not to let the background come into is I try to actually kind of wipe the slate clean, other than understanding the elements of what is being presented to me. I try not let any of my experiences kind of roll into it. And I think the only thing I let roll into it is the expectation that the parties are prepared. The expectation that the parties know what they're doing when they come before me, that they are prepared. And then with pro se, I have a different set of expectations because I do a lot of pro se. But for attorneys, the expectation is that they're prepared. So that's really the only thing coming in from the background that I'll let really kind of come in, is that idea that, if you're here for a hearing or a trial, you're prepared. You should be prepared.
That makes perfect sense. And we're actually going to get into some of the things that, you want to see and don't want to see in front of you. So feel free to talk about pro ses as well as attorneys, because this is going out to everyone that I can put it in front of. So that'll definitely help everyone who's going to be in front of you understand your kind of philosophy going forward. But before we switch into motions practice, got one last question here.
Sure.
What do you think the hallmarks of a good judge are?
Listen more and shut up, which is going to be kind of odd for me to do. Yeah, no, I'm serious. It's going to be odd for me to do today because I'm going to be sitting here talking the entire time. But one of the judges that I have immense respect for, and who passed away last year, which is Judge Spurlock, and then also another judge, Judge Ralph Swearingen and JP, who I've got in Tarrant County, who I've got a lot of respect for. They both gave me, and my story about how I became a judge is also kind of funny. So I called them the night that I found out that I was going to be a judge the next morning. And I said, what do I need to do? And both of them had the same thing, which was judges get in trouble for what they say, not what they don't say. They said, make sure that you say little, listen a lot, and document everything. And I've really tried to hold true to that mantra since 2012, because I've been on the bench since 2012. And so I've really tried to hold to that mantra as I go through things. So, yeah.
Excellent. Excellent.
That's amazing. Your background is quite impressive. But I think let's get into some motions practice, some substantive aspects. So about how much time do you think you allocate to reading motions during your day?
So the court that really has a heavy motion practice that I do is the one I'm a visiting judge up in Tarrant County with the debt claims and with the evictions. That's the only ones that are real motion heavy. The criminal cases are not, but I'm going to put a caveat to that in a second. But what I will tell you is, like we have an 8 o'clock docket. When I'm visiting judge, I have an 8 o'clock docket, a 9 o'clock docket, a 10 o'clock docket for, say, evictions. And that is very, very much a motions practice. They have the plaintiff has to meet certain requirements. And one of the things that I will do is I try to get there to the court early enough that I am reading through each set of dockets to make sure that their pleadings and what they have submitted is correct before we go into the hearing. So what's interesting is what those lawyers don't know is that I've already been through it. I already know if they've hit the check marks or that they haven't hit the check marks. I might have some clarification questions, but for the most part, I have spent almost equal amount of time before that docket to really make sure that they've met that. And you know, and I realize that I'm in one of the lower courts, and you know, JP and municipal courts are, you know, your lowest level trial courts and that type of item. But you know, like when you're doing the eviction docket, you're dramatically changing someone's life and trajectory. And so I think it's owed to the plaintiff and the defendant that I actually read that stuff through. Now, I'll tell you, as a practicing attorney, I know for a fact, I would probably say only about 50% of the judges on before ever read the motions that I've ever done. And I know that simply because of the questions that they ask me. And I'm sitting there thinking, you know, if you read the first page or the first paragraph, you would already know that answer. So it is frustrating for me, and I think lawyers have a right to be frustrated that they don't, because it doesn't take long to read a motion. I mean, really, when you get into it, you can go into there's parts of you, and you know this as an attorney, there's parts of the motion that are actually, what's the point, right? You can read that paragraph and develop that idea and know, if you read that, you're going to be so much better prepared to go into it. So I try to spend time doing it. So,
well, in that vein, having now known that you spend time reading these motions and understanding what these people are presenting, what matters more to you? Is it the written motion or the oral argument that comes with it? And how do you balance that?
Well, in my world, and I think it's going to be different at the district level, in my world, because we're looking at, did the plaintiff satisfy a very specific element, and that element has to be done through evidence. If they have done their motions correctly and attached the exhibits, then it really is 90% their motions and their exhibits. Now, with pro ses, that's a different subject. So then it completely reverses with it, because a lot of times they've submitted papers. Like, for instance, last week I had a woman who submitted an email to the Rental Assistance Program of Texas. Okay. Now, could she authenticate that correctly? Was it in the proper motion? Was there a business record affidavit attached to it? No, it's not. But because of the rules of practice within the JP court, I can actually ask questions for the person. So in that case, the oral testimony is going to be a lot more important than that. So, you know, for instance, I just asked her the questions. I said, well, when did you submit this? Who did you submit it to? Do you remember submitting it? You know, have you received any supply back? You know, that type of thing. And, you know, she actually won her case. Well, she got her stay. She got her stay for eviction, because she presented proof that she's part of that eviction diversion program, and that the other side, you know, and then I asked the other side, did they receive notice? The other side received notice. So she won 100% on oral, but 10% because she had submitted some document that indicated to me that there was something done correctly. So I think with lawyers and pro se, you kind of have to balance that out, and kind of make that determination with it. Now, I will tell you, on the criminal side, it is a little different. So I do get motions because I'm in court, 2 courts of record. I do get motions, and I do have to read those motions, and I do listen to the oral argument, because normally it is a fact determinative issue. And so I understand from their motion, the procedure or case law, but I really want to understand the application of their fact. And so that, I would tell you, is coming down to a 50-50, more of a 50-50 issue. The motion prepares me for what I need to focus in on, and then I also check it. So I do my own little research, you know, and a lot of times it's very quick. You know, has the case been overturned? Is that case still pending? That type of an item. But if that case is good law, then I'm then going to sit there and say, okay, how does this fact determine it? And then I'm listening to how the state and the defense discuss that. And that's pro se and with attorneys. I've actually been very impressed with pro ses being able to articulate, you know, this is the key fact, Your Honor, that we want you to look at in terms of the case.
That's amazing. And I know you said things tend to be different in district versus JP, but do you receive typically motions for summary judgment? And if you do, okay.
No, not really. Let me put it this way. In the debt claim cases, yes, there's dispositive motions that are filed all the time. The issue is that my personal attitude is that the parties really need to look at alternative dispute resolution on those debt claim, because a summary judgment in that scenario or a dispositive judgment in that scenario is going to create a piece of paper that probably isn't going to get anything. Whereas both the plaintiff and the defendant can probably resolve their debt issue properly with some ADR, specifically with mediation. So, but no, not like what you see in the district court. And I will tell you from a federal, because I do practice in the federal court, and I've done not a lot, but at least once a year, I have an employment discrimination case. On average, I have one employment discrimination case. I'm in the federal courts, and I have to fight those dispositive motions and that type of an item. So I will tell you that at the federal, and then of course at the district and at the county, I do see a lot more summary judgment, but I don't see it in my world. I don't.
So when it comes to dispositive motions, do you usually like background before the technical aspects of the motion, the substantive aspects, or do we skip the background?
I'm going to tell you that I kind of prefer just enough, like the one sentence, just to cue me into it, because I've read it. I understand, I've read the case. I've looked at the case file. So I don't need as much background as others, but what does help me is because if I've got a bunch of stuff in front of me, it helps me just jog the memory. So, if the lawyer says, Your Honor, just as a reminder, this is XYZ company's claim, and it's we've pled for $5,000. This originated off of something in 1985. Whatever it is, just enough little trigger on that is fine. The other day, I had a brand new lawyer, and I knew what the partner was doing, and I let that brand new lawyer go on a lot longer than what I normally would, because he needed to have that experience of being able to put it. But he wasn't succinct. I would say that he probably needs to be a little bit more succinct in what he's saying and a little less conclusory. But, other than that, no, I don't need a whole lot of background.
So brevity is the soul of wit still.
Yeah, I really do. I mean, I think that you need to remind it. Me as a defense attorney, and I'm sure the judges on front of would probably tell you that they would disagree with this. But one of the things that I try to do with my motions is I'll sit there and say, Your Honor, if you remember, we were here 2 months ago on this issue. This is how you ruled. This is how you ruled. The overall case is about this. Today, Your Honor, this is what we're asking for. What was that? 15, 20 seconds at most. So it was enough to jog the judge's memory, and then to highlight, this is what we're here today to do. But that's also tactical, because generally the state is attempting to confuse the issue, because that's the only way they're going to win. And so I want the judge focused on the one singular point. So there's a little bit of tactics going on there too.
Always. I think that would be actually huge for, the people who are going to be in front of you to know that.
Right.
Let's talk a little bit about the hearings, just hearings practice in general. Okay. Do you prefer electronic or physical exhibits?
Well, right now, everything's been electronic. And so I've gotten used to the electronic exhibits. I will tell you, I think there's a time and place for it. I'm a big proponent of remote hearings. I think that there is a large segment of what we do within the judiciary and within the courts that we could move to remote hearings to increase access for people without resources, that would lower costs for people to litigate their cases, and then also improve efficiency within our courts. So I do believe in technology for that. At the same time, there are times that I think the judges and attorneys have to be smart enough to say, what evidence are we dealing with? And I'll give you an example. Is I had a yearbook that was used as a police identification tool. Now, I could scan it in electronically, but there's something lost with when we're trying to demonstrate what the complaining witness did during their identification, that flipping the page, that action, that looking, watching how the body language of the person, I do think that needs to be in person. I do think that needs to be physical. That said, on my eviction and on my debt claim side, electronic, we can do everything electronic, because it's either you have the document or you don't have the document, and the document can easily be displayed on the screen. So I think, would I say, do I have a preference one way or the other? No. What I would say is we need to use our judicial minds and say, is this hearing appropriate for electronic and remote?
Makes sense to me.
To me, but you would be surprised. I have people that are so mad at my position regarding that we should be pushing some of these things too. And I've had people sit there and say, that's ridiculous. Everything needs to be in person. And I'm sitting there thinking, no, not really. It doesn't, So anyway.
I'm a huge fan of the, I know that COVID has been very unfortunate for a lot of people, but for the legal industry as a whole, I think that it's dragged us about 100 years into the future, because prior to COVID, Laurel and I had a telephonic hearing yesterday where we had to get on the telephone, and we had like 4 or 5 false starts because there was this, well, this phone won't connect to this phone, and then we have to call into the judge and pull all of this. And it was just like, why can't we just do this via Zoom? We've got opposing counsel down in Houston. We're in Dallas. The judge is over in Dallas. I'm at home. Laurel's in Tarrant County. Like, let's just get on Zoom and we can put everything in front of the judge, that way.
And I will agree with you. I think on Zoom as a judge, I like using Zoom as a judge over the telephone. And the reason why is because I can read body language. And I'm going to tell you, that is a major form of communication. And if you look at case law talks about the reason why appellate courts defer to the trier of fact. And if you read it, it talks about the fact that the trier of fact of the trial court level is there to view the attitude, the facial expressions, the communication, the body language. So the appellate courts have figured out body language and nonverbal communication is important for determining the weight of the evidence and the veracity of the witness. So I like Zoom for it. Now, if we're having a pretrial logistics hearing, and we do these a lot more within the federal system, where the judge is like, okay, folks, this is what we think, this is the time, this is the schedule, this is calendaring. Yeah, use that phone system. But, I had a simple prove up. It was literally 3.5 minutes. I timed it. And the court forced us to come in person. So if I applied the ethics as an attorney, I would have been able to bill my client for 6 minutes, right? Okay. So I would have been able to bill my client for 6 minutes. Whereas by doing it in person, I had to bill my client for an hour plus travel. And it was silly. It was a simple name change prove up. And I know that a lot of attorneys probably watch this are like, well, yeah, you idiot. That's how you make money. You know what? I deal with a lot of rural people. And I deal with a lot of, and a $3,000 name change in a district court, it's not going to be helpful to them. Whereas, if I can do it for $1,000 after I do all my drafting and filing fees and things like that, and I'm only spending 10 minutes on the Zoom, there's a lot I can do with that. And there's a lot more people I can help with that. And so I don't know. I have a different mentality. Lawyers tell me that that's why I'm poor. So, and that's I'm okay with that. I can live with
man, I disagree with that last part. I've seen your building. I've seen your building there. But on the topic of hearings, what's your I've heard enough signal?
I try not to do it because I do pro se. What I will tell you is, if I start going through and you start seeing me do my signature, not making notes, if you start doing my signature, that means I've already probably come up with a determination or ruling. But the way I try not to do, I'm tired with it, is what I'll do is I'll ask a question. Okay. So like the other day when I was telling you about the attorney that was going on, he was kind of going on, he had proven his point. He was getting ready to prove the point again. And all I said was, Counselor, I do have a question about your non-military affidavit. Could you bring me that up? And so that moved him forward. with it. And I don't know if he knew that I had enough or not, but I try not to do it because
he will now.
Yeah, he will now. But I try not to do it in a rude fashion, right? Because I'm dealing with pro se. A lot of the people that are before me are pro se. And I cannot tell you how many times people will sit there and they just want to be heard. And so if I give them 5 minutes to do whatever they're saying, they want to say and stuff like that, and I try to be an active listener, they generally, even after I have to find against them, they're generally like, Judge, thanks for listening to me. Man, I screwed up, but thanks for listening to me. And you know what? And if they leave the court with that kind of attitude that, yeah, I did this, I screwed up, but at least I got a fair shake. I think that's kind of the important part. So I try not to give that signal. But if you start seeing me sign my name, that's probably when you know that I've already done it.
Good to know. Good to know. Now I need, like the box to stand on though, because I know that you're higher up. So I'm gonna have to be looking over.
Yeah.
All right. On the topic of pro ses and attorneys themselves, what makes for a good hearing presentation from our, and by our, I mean, Laurel and I are both attorneys, you're an attorney. So when the pro ses and the attorneys are in front of you, what makes for a good hearing presentation from your perspective as the judge?
They're prepared. I mean, plain and simple, you're prepared. You have your documents. You have filed your documents according to the local rules, specifically with all these remote hearings. There's now local rules about how soon in advance you have to have your documents in. You have filed your documents and that type of thing. And that you know how to articulate it. I had a person the other day that they were proving up damages and they couldn't do it. They didn't have the breakdown for damages. And they lost their case because they could not prove damages. I'm 100% confident in telling you this, that had the person the day before taken about 30 minutes and sat there and said, $100 for this, $3,000 for this, $400 for this, $500 for this, $600 for this, blah, 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 and then attach the receipts and put it in an exhibit and sent it to the court, which they were eligible to do, they would have actually won their case. I actually recessed the case or paused the case for 15 minutes and told the parties, if you have any additional documents that you want the court to consider, please submit it. The person still did not take the opportunity just to submit their receipts. And so they lost the case. The case for them, and I realize in your world as district court, this is nothing, but for them, it was $9,000. And based upon what I know, that was probably maybe close to 25% of that person's annual income per year. So that's significant to them. It's not the millions of dollars that, the Hammer talks about or anything like that. But, for them, that was a significant thing. And so, but they literally they weren't prepared. They couldn't articulate it. And that was, and like with eviction, property managers and people that represent property managers have to articulate where they come up with back rent. So the really good ones will come in and say, Your Honor, we're asking for $5,000, $1,000 for April, $1,000 for March, $1,000 for May, $1,000 for June. And then because today's the 29th day, it's been prorated at X, blah, blah, blah. And it's actually this plus this fee. Therefore, we are asking for $5,000. You present that, the documents are there, you're winning. That's it. If you don't have it, you're not going to win.
I feel like we're getting the cheat codes. Like I really do. Laura, what are your thoughts so far?
So I'm very excited actually. But I want to know a little bit more about hearings and charts, graphs, those kinds of things.
Well, I don't deal with a lot of them. So I don't use that from a judicial perspective. I will tell you, I have used them in my employment discrimination cases in which we've had graphs and charts that do the math and show everything like that. And they have resulted in my clients having, I would probably say, a 25% better outcome in their damages. So I can get specific with that. I can track that. So that's not hyperbole. I can go back, and in fact, in one of my classes, I show the students how we use the graph in order to do that. And I do think visualization is good on it. It's just, you have to make a determination. Is it really educating the trier of fact?
That makes perfect sense. Let's move on to trial practice. Sorry, I think we skipped around a little bit. Laurel, if you want to take care of the trial practice section.
I do, because charts and graphs, I feel like, kind of go into that really well. Here's a fun one. How do you define hearsay?
My cousin's uncle's brother said that's definitely good. Yeah, that's definitely, you have to understand that dealing with pro se, hearsay is really common. And so I really try to use just the basic definition, an out of court statement, and made by another person, and that they're trying to quote from it. I really get, I know when we get on my criminal side, we get a little bit more technical into that, and there's more, all the exceptions to it. But really, in my pro ses, they will try to prove their case with nothing but hearsay. And so it's really kind of weeding things through. And I have to then always come back and ask the question, okay, I understand that Joe Bob said that, but I can't consider what Joe Bob said. I need to know what you heard. What did you hear from the plaintiff? What did you hear from the defendant? Okay. What did you see? Were you there? So a lot of times I have to ask those questions, because also with pro ses, they don't know how to object. And so my big thing with hearsay is I have to basically, as a judge, identify it, discard it, and then ask a follow-up question to determine whether or not that testimony has validity or whether I need to move it to the side.
There are so many processes going on in your head at once.
Yes.
Yeah, I will tell you, with pro se, it is an active bench. You have to be an active bench when you're dealing with a lot of pro se.
Keeping in mind that you deal with a lot of pro se, in a bench trial, is there a difference in impact in procedure and then practical effect on the parties as to how you would make a determination?
Yeah, well, I mean, one thing is procedure with bench, and I've seen this as a defense attorney. Procedure seems to start going out of the way a lot, and partly because it's what I just said about the judge, because the judge is also the trier of fact on the issues. He or she is sitting there going, yeah, no, that's hearsay. No, I'm not going to think about that. No, I'm not going to allow that in. Now they're doing that silently in their mind, but a lot of procedure kind of goes out the way whenever it's a bench and you're dealing with it, because there is no jury that you have to protect their hearing. As the judge, you're going to hear it. If there was a jury, you're going to hear it all anyway, and you have to set some of that stuff aside. You're trained to set that aside. What I'm looking for when we talk about procedure within the bench trials and things like that is, can they authenticate their evidence, and do that when they make a conclusory statement? What do they have to back that up? And so that's what I'm looking at. That's what when you say procedure, that's really the procedure that I'm looking for in terms of that. The other side of the procedure is the general flow of a bench trial. And is there a clear delineation between the state's case or the plaintiff's case and the defendant's case? A lot of times defendants with pro se will try to interject themselves into the plaintiff's case in chief. And so making sure that people understand there's a time that you're in charge and there's a time that they're in charge, and please respect that. So that procedure, I do really try to hold to. The objections and things like that in a bench trial, I'm not as concerned about that, because I'm already like, no, I'm not going to consider what you said Jim Bob said. I am going to consider that piece of evidence that you had.
So moving to the jury trial aspect, some judges cover what lawyers will question in voir dire. Some judges prefer to do most of the voir dire. How do you approach that, or let lawyers handle that?
I let the lawyers question, and then I have a basic set of voir dire questions as a judge that I am going to ask to make sure that we are clear. So what I will do is and the reason why is because I've seen a lot of attorneys not do this, and I don't understand that aspect of it. Maybe because attorneys aren't doing voir dire that often. But for instance, one of the questions I ask is the witness question. So what I will do is I let the attorneys do voir dire, but then if they don't cover certain things, I will ask the questions like, do you know these witnesses? And here's the list of witnesses. I am shocked at how many lawyers don't do that. Because the only reason why I do it is because I learned a lesson when I was not a lawyer in that jury that I was a jury foreperson of. All of a sudden, a former employee was called as a witness. Now, remind you, I wasn't an attorney at this time, so I didn't know what should have happened or what not. And all of a sudden, I recognized the witness as a former employee. And so here I am as a non-lawyer juror and we were 75% of the way through that jury trial. I had to raise my hand. Do you have any idea how terrifying that is for a non-lawyer to raise their hand in the middle of a trial and say, Your Honor, I know that witness, and then have the whole courtroom cleared, and then I had to be voir dired, and you could tell that the judge and the lawyers were like, oh my God, we're going to get a mistrial. And I thought I did something wrong. Then in law school, I remember the day when they were doing it in procedure, and I'm sitting there going, wait a minute, why did I feel guilty? So one of the things that I do now is I have a list of questions that if the lawyers cover, great. But if the lawyers don't cover, I'm asking.
They don't teach voir dire in law school.
Very few do. Very few do. And even some of the schools that do these, practice courts and all these other things that they do, even that they really don't do a good job with voir dire because it's hard to do a mock voir dire.
I mean, that makes sense. That's something that maybe I should look into. But I've got enough on my plate right now. I know that you've been here for quite a while now, so let's move on to some general practice tips as we start to kind of wrap this one up. What are your biggest pet peeves?
Not being prepared, not interviewing your witnesses, not knowing what your witnesses are going to say. That's my number one, is you better investigate your case. And I mean that from a defendant standpoint, state or a plaintiff's point of view. You better investigate your case. You better know what your witnesses are going to say. And if it's appropriate and you can find out what the witness is and interview the witnesses on the other side, do it. Because I'm going to tell you, a lot of cases nowadays should never have been brought if proper investigation was done. And I mean that on the civil and on the criminal side, is that you really need to investigate your case before you bring it. And if you decide to bring it, you better invest the opposing party's case to find out what holes you have. Because if you don't, it's glaring and it wastes everyone's time.
I have a question prepared as a follow-up to that. What are your favorite things to see from lawyers? But I have a funny feeling you just answered that.
Pretty much.
Awesome. So what do you wish more lawyers would do in your court outside of preparation?
I wish that they would call the other side before the day before court. Call them and see if they can't reach an agreement, specifically on the debt claim cases and on eviction cases. What I will tell you is that I would say that, and I will say where I'm a visiting judge, they do a lot of ADR. Even those that get through the ADR process it's mandatory in that court, I would still say 50% of them would have been better served if they would have taken the opportunity to do mediation, or try this on as a lawyer, pick up a phone and call the opposing party or call the opposing attorney. It astounds me when we ask the question, have you met the opposing attorney? No. Have you guys ever talked? No. Would you like an opportunity to talk today? Yeah, while we're in court, let's talk today. And I'm like, you have wasted everyone's time doing it. Pick up the phone, call the attorney a couple weeks out before your hearing and say, hey, where are we at on this? And be civil about it. if your case is so good you don't want to mediate, then communicate that, but at least have a conversation about it. Because a lot of times those judgments are just pieces of paper. Whereas if you had mediated it or talked through them with it, or maybe helped them through the rental assistance program or something else, you would probably have money. I recently, I know we're going long, but I had a company who all they had to do was accept a check, and they were going to get $10,000 to $15,000. So in other words, they would have been brought whole. They would have been brought whole, but because they hadn't talked to the other party, because they put their foot down, what they got is they got a piece of paper with my signature on it that says you're owed $15,000. Well, congratulations, got a piece of paper, but you could have had a check, and that's all by just picking up the phone. But I would have preferred to have the check.
I tend to agree. That's far more desirable. So what adds to credibility in your eyes from the pro ses or the lawyers?
Prepared, respectful, and has made an attempt, an honest attempt to communicate with the other side. I will tell you that there's a couple lawyers that a couple of us judges talk about, and other people talk about, that are in these different courts, that when they show up, we know that that hearing is going to be well done. It's going to be respectful. And at the end of the day, there's going to be a resolution. That resolution may not be what that lawyer wanted, but it's going to be a resolution. And a lot of it has, and those are the three hallmarks: that lawyer is prepared, all exhibits are in, all motions are in, all pleadings are in, and the lawyer has made an attempt to communicate with the other party and resolve the dispute. That to me just speaks volumes in terms of somebody.
See, I knew that somewhere y'all were talking about us, because y'all have a very limited, circle, and, y'all just periodically get together and powwow about attorneys, who's good, who's bad, who's terrible. I think I'm getting a reputation in Tarrant County for being very interesting or zealous. I don't know if that's good or bad yet, but we're going to go with it for now.
That's funny. That is funny. By the way, the other group of people, if you want to know about reputations, the other group of people that you might be able to get your information from is mediators, because a lot of times my personal experience is mediators tend to have the same type of outlook as judges regarding attorneys. So if you ever want critical feedback, talk to a mediator.
That's a good idea. That's interesting. I never thought about that. Thank you for that one. All right. What else do we and what else do we, the lawyers and individuals that are practicing in front of you, need to know before we get to your courtroom? I mean, you've made a big impression or big statement about preparation, respect, communication prior.
This is something that I always have a problem with, because I practice in so many counties, and so this is I'm showing you my vulnerability side, my human side. The one thing that I don't do well, and I know the one thing I don't do well, and I always have to catch myself, and normally I catch myself like the day before, and I'm always mad at myself for doing it, is the local rules. I know the rules, Texas Rules of Civil Procedure. I know the Code of Criminal Procedure. I know that type of stuff. Where I've gotten myself into trouble as a lawyer, and where I've gotten myself into trouble, or where I've seen lawyers get themselves into trouble in front of me, is not knowing the local rules and not knowing the process. Now, I will tell you that my as a practicing attorney and as a judge, I have practiced in over 75 different counties in the state of Texas. That's very rare. Most attorneys will practice in 1 or 2 counties at most. I will tell you, every county is different in their procedures. So take a rule of civil procedure, and it will be applied and used differently in all counties of the state of Texas. So one of the things that I know, here, trust me. And with Zoom, that's a whole different ballgame. What I try to do is I will call the clerk or court administrator. I will identify myself as a know-nothing attorney from outside the county, and I will ask them, what do I need to know? And do you have local rules? And a lot of times they'll tell me local rules. And a lot of times they'll tell me, oh, hey, you need to do this at this date, this at this date. And oh, the judge really likes this. If you go in with humility, you go in with respect, and you say, look, I'm just trying to be a conscientious attorney in your jurisdiction, I will tell you the court admins and clerks will typically bend over backwards for you. And knowing the local rules. And that's got me into more trouble. And I always forget to do them until the last minute. So do better than me.
That makes sense. And one of our goals is to talk to the judges from all over Texas to make sure that we're understanding, like, hey, what do we need to know about your setup in particular before we get there? Because we don't want to make it any harder on ourselves than, absolutely possible, which leads to better outcomes for clients in general. All right, Laurel.
So last couple of questions.
Okay.
Who do you think has been an amazing example of a judge?
I will tell you that I've had a couple judges that I've really appreciated. Judge Joe Spurlock, of course. I mean, he's like the archetype judge for me. Judge Swearingen's been a very impactful judge in terms of mentoring me and that type of a thing. I will tell you that I appreciate it. I appreciate being a lawyer under Judge Youngblood in Milam County. I think he has a great temperament. I think if judges had that type of temperament, I think we would be moving in the right direction. Phil Robertson, who's retired in Bosque County, he also has the right temperament. I really appreciated him. Those are some folks that I've practiced in, that I've seen that I thought were really just outstanding in terms of temperament. And that's the thing that I would tell you is probably why all those judges kind of, in my mind, they were always respectful to anyone that came in front of them. There was also Judge Mayfield out of McLennan County. I thought he was very good at what he did, but I thought their temperament was what set them apart, is how respectful. And I'd be remiss if I didn't say Mike Freeman. I interned under Mike Freeman, and Mike taught me the simple value of congratulating people. He did a drug court, and I always thought it was funny that he always gave Snickers. He had these huge Snickers bars, and if anyone completed their portion of their drug court process that quarter, he would give them a Snickers bar. And at first I thought that was really stupid. Who cares about a Snickers bar? But then I learned very quickly that act, for most of those defendants, a judge giving them something was huge in their lives. And it was a major motivating factor for them to do the right thing. I mean, think about that. You're changing a person's criminal behavior by just a very simple act of showing them the common decency of respect and acknowledging their work. And acknowledging their work with something as simple as a Snickers bar. Those judges all had the temperament. They all, to me, understood what it meant to listen to the parties. And I think that's what probably was the biggest deal.
So
that's phenomenal. Hungry, why wait?
That's not what that meant.
So as a judge, what has been your least favorite moment on the bench?
This is only the purview of a municipal judge that would say this. My least favorite has been putting down dogs. But most of the time they're cruel. It's been cruel, bad treatment, and they've been made to be aggressive, and they're malnourished, and they're hurt, and but that's horrible. I hate doing that, because the poor dog has no control over what the humans did to it, and I hate doing that.
Well, let's talk about something better. What's your most favorite moment you've had on the bench?
I don't know if it's favorite. It's just the funniest is that I had to put into recess a jury trial in one of my municipal courts because a large combine caught on fire in a field during harvest, and half the jury, the defendant, and two of the witnesses were all on the volunteer fire department. And so they all had to go and put out the fire. So that by far has been the funniest thing, is sitting there and everyone's fire beepers goes off. And I'm looking there, it's half the jury, the defendant, two of the witnesses. And I'm like, all right, we're going to go into recess. We'll recess this and come back, So anyway, that was by far the funniest.
Man, I mean, you got a whole bunch of people together putting out a fire, maybe discussing their case.
Yeah, let's just say that I don't remember what happened, but I'm pretty sure that we didn't come back. I'm pretty sure that the state, I think, decided, we're just not going to worry about it.
That's
I
some serious.
I'll have to go back and look now.
That's some serious impetus to settle out of court. But all right.
All right. Last one. Tell the audience, the lawyers, the pro ses, anybody listening, anything you'd want them to know about. Just something. I
think I've already said it, to be perfectly honest with you. I mean, really the only thing I would tell you is that, we have an incredible judicial system, and it just requires people to be part of it, and, take that jury summons, lawyers take that pro bono case, get in there, and this is how we protect our Constitution. I mean, day in, day out. So I would just say be active in the system.
Excellent.
All right, and just to reintroduce everybody, today we've had the Honorable Judge Matthew Wright in front of us today. Thank you very much, Your Honor, for coming. I am Aaron Cartwright. I am a business, construction, and securities litigator in Dallas, Texas, but I practice all over the state of Texas.
And I'm Laurel Curtis. I've been your co-host today. I also work with Aaron. We do a variety of construction litigation, business litigation, and I also take on some general civil litigation in the practice statewide. So it's a fun ride. Judge Wright, thank you so much for your time today.
Yeah.
Thank you very much, Judge Wright. We greatly appreciate it.
Thank you all.
All right. Adios.
All right.